This is going to be tough as a litigator because I'm not used to standing in one place, but because we're filming, I will here. When I got out of law school, I knew I was going to be a trial lawyer. I was going to be out there defending the wrongfully accused. I was going to be helping those injured in automobile accidents, all those great things we think trial lawyers will do. Well, I did get to do a lot of that, and I still do a lot of that, but thanks to living and working in northwest Wisconsin, I have come to know so much more. I have found out that CWT is not shorthand for country, western, and twang. I know it's not only hunters and fishermen who dislike the DNR, and never trust a guy from New Jersey when it comes to making cheese. I learned all of those things in lawsuits that I've either defended or prosecuted over the past few years. And one other thing I've learned, or thought I had learned, was the definition of an implement of husbandry. About 10, maybe even 15 years ago, I represented one of our local large farm operations, and they'd been cited for operating their implement of husbandry on the highway. Well, in Wisconsin, a highway is defined as any roadway that's open to the public. So a town road's a highway. Quite frankly, your driveway might be considered a highway if you open it to the public. But be that as it may, the problem here was that one of the fields in the home farm was in one place, but other fields were about 10 miles down the road. And so to get from point A to point B, it was necessary to drive on the town road. The local state patrol officer did not believe that that was appropriate and cited the producer. We went to court in St. Croix County in this case, and we discussed what was an implement of husbandry. Well, as many of you may know, the definition, and it's set forth in a statute, now it's set forth in 2 statutes, and we'll get to that, but it's a piece, a vehicle or a piece of equipment or machinery designed for agricultural purposes, used exclusively in the conduct of ag operations, and used principally off the highway. The state patrol's position was driving from home farm to home or to farm field was not principally off the highway because it took this particular implement close to 45 minutes to make that trip. Well, I believe it was Judge Needham, as I recall, in his wisdom, found that no, the purpose of this vehicle was to be used in the field. It was necessary as part of the farm operation to get from point A to point B, and if you had to go on the roadway to do it, that was the only way to do it, so the principal purpose of this vehicle was to be used off the road. Seems logical and fair enough. And you can still see, obviously, implements all over our local roadways. Well, with the change in technology, the larger farm operations and good old-fashioned ingenuity, people have figured out, well, there's better ways to do certain things. And one of the ways to do that is taking a dump truck. That's really not the right picture, but thanks, Bridget, for giving me a picture. But what we have in a case going on right now is what I would call a modified dump truck. And it's large enough to be a commercial motor vehicle if it was operated as a dump truck. The vehicle, though, has been modified with a beater box and a spreader system on it, meaning the floor can move, so it's moving manure out of the back and then spreading it in the fields. Well, what this vehicle does is what used to take 20 or 30 tractor pulling a trailer loads, and it does it in one. And again, here's what we have. We have home farm, 10 miles away, 4 miles away, 3 miles away, and across the road we have farm fields. Well, they're taking the manure from home farm to the field 10 miles away. By the way, they've got all the approved permits from the DNR for spreading there. They've filed their manure plan on how they're going to spread, so that's all approved. The State Patrol, only one State Patrol area has been, as far as we can tell, trying to enforce this law. There's also been some over near Wausau who've been trying to enforce it, but that's more on the overweight as opposed to overwidth. The problem with this vehicle as modified is it has farm tires for use in the field, and it has a gearbox on the outside. And when you add the farm tires and the gearbox, it makes this about 6 inches too wide. Now, since the ticket was written, we've modified, or the client has modified it again. They're still 2 inches wide, even with modifications, so it's not simply a matter of changing the truck. But in any event, the vehicle is operated on the road. It's given a ticket that it is over width. Well, as many of you may know, you can get what's called an over width permit from DOT if you meet certain requirements. Well, DOT, the State Patrol guy, said, why don't you just get a permit? Great idea. Ask for a permit. No, you can't get a permit. Why can't you get a permit? Because it's a dual-use vehicle. In other words, you could use it for spreading manure, but if you cleared the manure out, you could also use it to carry bricks. You could use it to carry different things. So we can't give you a permit because it's not truly the type of vehicle that's permittable. Okay, so now we're in this kind of darned if we do, darned if we don't, because it's over width. They're saying it's not an implement of husbandry, and I'll tell you why in a second here. But they're also saying you can't get a permit for it. So we've got trucks that are being specifically manufactured by Wisconsin manufacturers, some of them quite large, putting together vehicles to be used specifically in Wisconsin, thinking they're following the law, the farmer thinking they're following the law, and now they're getting ticketed and told they can't do this. Well, State Patrol and DOT's position is that along about almost 20 years ago now, the change in the law where they tightened up the commercial motor vehicle license restrictions, when they did that, what they meant to do is make sure that big trucks couldn't operate unless they met certain requirements. And the previous implement of husbandry definition only dealt with your ability to not have to register your vehicle. In other words, if you were an implement of husbandry, if you were designed for ag purposes, used exclusively in ag operations and principally off the highway, you didn't have to register the vehicle. Well, that's still true, everybody. You still don't have to register the vehicle, but if you now meet the definition of a farm truck, which is, I think, sub B of this statute, if you are a farm truck or a motor truck, in that situation, you are not an implement of husbandry for purposes of operating on the roadways. And so what they're saying is farm trucks are defined as in 24B, let's get it here, a motor truck having a gross weight of less than 38,000, owned, leased, and operated by a farmer and used primarily for the transportation of supplies, farm equipment, and products. Okay, so that's your transport vehicles. They have the same definition for over 38,000. So you have that, and then you have the implement of husbandry under the new statute, which changed, said that implement of husbandry does not include a farm truck or a motor truck. So DOT's position is, yes, if you have it as an implement of husbandry, but it's a farm truck or a motor truck, you can't get the benefit of the statute. Well, it's a real problem because as far as we could tell, and we've met with some of the farm groups around the state, these trucks are operating everywhere on the belief they are implements of husbandry. the legislature, there are a couple of legislators looking at the issue. And hopefully in 2013, there's going to be some legislative changes. However, there is a lobby on the other side of this, and that's the towns, the counties, and the cities, and the DOT, because of the damage they claim that is done to the roads and the safety issue. Now, the safety issue goes either way, because you have to ask what's safer, one truck going down the road or 20 or 30 tractors pulling trailers. But that's, that'll probably be dealt with. Well, let me just kind of tell you quickly what happened in this case. We basically made the same argument we made over 10 years ago, that the purpose here was used principally off the highway. We just have to transport from A to B, and that's the only time we're on the highway. Pepin County, Judge Duval agreed with the DNR, or the DOT, that it was a farm truck, that it was a motor truck, either way, because manure is a product in the judge's mind, even though it was our manure from our farm, used on our fields, not transferred to anybody else. But he said manure is a commodity. You can buy and sell it, therefore it meets the definition. But the judge said, but I still have to decide this principally off the highway issue. And what he said was, well, let's talk about everything this truck does. We fill it up, we take it down the highway, we go to the field, we spread it. Well, they've gotten very good at filling the truck. They just take an end loader, and within about 5 minutes, it's filled. They can travel down the highway now at highway speeds, so they are a little bit quicker on the highway, but they're still on the highway for a significant period of time. But this vehicle can spread so efficiently that it's done and back to the farm to pick up more in no time. So it might be out in the field for 15, 20 minutes spreading. Well, Judge Duval's theory on this was when they had, you may have heard about what they call the O'Cray produce case, the potato farm case, and that was the term de minimis was used. Is the operation on the highway de minimis? Well, Judge Duval said, de minimis means, in my mind, a little bit. I'm adding all this up. I'm finding this truck to get to the 10-mile-away field spends about 25 to 30% of its time on the road. That's not de minimis. That, therefore, is being used more, or being used enough on the highway that it's not an implement of husbandry. The state didn't like the fact he even looked at that issue. They said if it's a farm truck, the farmer loses because it shouldn't be on the road at all without a license. We thought he was wrong there. The word, the statute uses principally, the O'Cray case used primarily. De minimis was, in effect, a statement the court made in O'Cray that wasn't really the law, it's just what their observation was. So where are we sitting now? We lost. The guy got the ticket, or the farm got the ticket. It's on appeal, going to the Court of Appeals. We may have a decision 3 to 6, probably 6 months from now. But in the meantime, as I say in my title, it's clear as manure what this means. So far as we can tell, there is only 1 or 2 areas of the state where this is being enforced. We went to Dairy Business Association and asked if they would help. They said, quite frankly, we would just assume nobody really talks about this issue because in 70 counties of the state it's not a problem. But it's official DOT and state patrol position right now that farm trucks and motor trucks do not fit the definition of implement of husbandry and therefore are going to be licensed, need to be licensed. Now what that means for everybody is not simply the possibility of a ticket. It also means you have to insure it, most likely as a commercial vehicle as opposed to a farm vehicle. There may be restrictions on who can drive, when they can drive. So those are a lot of the gray areas that you're looking at right now. The outline is not really an outline, it's a description of what happened. You can read through it. I realize I ran through this all pretty quickly, but it sets forth what's going on. Not sure how this is going to end up. I want to just briefly touch on a few other issues that you should keep in mind, and then if there are questions, I can take them, or I'll be here when we're done. A few other things I've learned through litigation over the past few years. If you're going to move any earth on your farm, on your fields, in your driveway, on your farm driveways, check with NRCS and the DNR before you do it. If you don't, you may find yourself with a wetlands violation, which means loss of all farm program payments for a minimum of that year, potentially forever. So take care of those. Even though our farm economy is often operated on a handshake, get your contracts in writing, especially if it involves real estate, if it involves an option to purchase, if it involves a contract with a dairy or a cheese factory, get it in writing. This was brought up by Mike. If the police show up with a warrant, you do have a right to silence, and you should exercise that, but you should also cooperate. And the first thing you should probably do is get on the phone to a lawyer or your lawyer and say, the police are here. We will almost always advise you, cooperate. If they're going to come in, they're going to come in. Whether we're there, whether you let them, they're going to do it. Do not give statements until you have counsel. And the reason I say that is they're going to do the same darn interview tomorrow as they'll do today. But you'll feel a lot more comfortable giving that interview when you have counsel next to you. The other part of it is they don't want you to have your attorney or your financial advisor or that person sitting next to you, because they have the upper hand at that point. Waiting a day isn't going to harm anything. Cooperation is not the same as admissions. A couple other things that came up: do your estate planning. We've had to litigate a number of farm succession cases over the past few years where perhaps the will wasn't as clear as it should be, or maybe it was and the son who didn't get the farm couldn't believe it. So make sure it's written out and you've done those things. Planning costs a lot less than litigation. That's what I'll leave you with. Spend a little now can prevent a lot later, and I think that's the same with the immigration advice you just got, with the tax advice. Take the time to do it now, so you don't have to try to unravel the mess later. Questions? Yes? And I think everybody heard Ole, but the question being, okay, you have it under your farm, but it really should have been under your motor vehicle policy. Somebody's injured, now what's going to happen? You know, it's how this case came to be, the one we're dealing with. The vehicle that was involved got in an accident. State Patrol came, wrote the citation when they did all their testing afterwards. So I don't know the answer to that, but I talked to the state trooper who's involved, and I didn't mean if I painted him as a bad guy. I think he's just doing his job and what he's been told to do. But he raised that exact issue to me. He says, I am worried about all the farmers around here who may not have the right insurance on their vehicles. If indeed we're correct here, they should have different insurance. And he said, as I think you just said, here's what you should do, but it's your decision to make, Mr. and Ms. Farmer. And I don't have a perfect answer on that. I really don't know what to tell you, except work with your insurance people, explain what you have, and you know, you'll have to make those decisions. In this case, we didn't run into any problems because the insurer covered the loss even before it got to this point, I think. But it was a catastrophic injury. So, other questions? Thank you all.